Hi everyone, this is my presentation on competency to be executed and waive appeal rights. What is competency? This is just a review on what we've been learning about the last 2 weeks. The definition of a competent person differs in each unique situation within the court process. The closest to defining overall competency within the court is stated by Melton et al. As the requirement that defendants be able to understand and participate in the legal process. The degree of participation is different for each process. There's standing trial, waiving right to counsel, self-representation, sentencing, execution, and the right to appeal are all unique processes within our justice system that requires a person to be competent. Now, the degree of competency is different in each category or unique process that we have, and this PowerPoint presentation is only going to be talking about execution and then the right to appeal. Execution then versus now. The United States law has been against executing incompetent individuals since 1986. Ford versus Wainwright ruled that the Eighth Amendment, which bans cruel and unusual punishments, prohibited the execution of an insane person. Once again, the court did not create specific measurements or guidelines for competency for execution. And I say once again because the standards for competency for each stage of trial is very vague and very state dependent until it is taken to federal court. Judge Powell, from that same case, Ford versus Wainwright, did suggest that it would be considered cruel and unusual to execute a criminal that cannot comprehend what the punishment is or why they're receiving it. Most states that have allowed execution to be part of a sentence follows Judge Powell's suggestions and even some other Supreme Court cases related to competency. Execution then versus now continued. 34 out of 35 of the states that have adopted execution require mandatory review of the sentencing by the state's appellate court. That is without the defendant appealing with their attorney. And that fact was from, I believe that source is from 2005, so I'm not sure if more states have adopted the execution. While some states continue to use Powell's suggestions, the American Bar Association has become broader in terms of the standards for competency. Any individual that has a mental disorder or disability that significantly impairs his or her capacity to understand the nature and purpose of the punishment or to appreciate the reason for its imposition. The statement is used by both the ABA and the American Psychological Association. Any person who fits the statement above will, 1, not be able to be executed, and 2, not be able to appeal his or her rights. Now, what the statement doesn't add, and other cases I've found along my research do, a person with a mental disorder can be competent, and a person without a mental disorder can be incompetent. Although most incompetent cases do correlate with a mental disorder. Panetti versus Quarterman. This is a case that adjusted the Supreme Court's standards for competency. An adjustment to competency to be executed standards was made by the Supreme Court when Panetti understood his crime, why he was sentenced to death, and what the death penalty was, but he did not understand the state's real reason behind the punishment. He believed they were punishing him for acting on his religious beliefs. This case found that even if a defendant fits the standards made by Ford versus Wainwright ruling, he or she can still be found incompetent if his or her awareness of the crime does not associate with the awareness and reasoning of the community. A prisoner's awareness of the state's rationale for execution is not the same as a rational understanding of it. An example of a court case that the defendant's competency to be executed is put into question: Panetti versus Dretke. Scott Panetti was a defendant who was sentenced to death in the Texas State Court for murdering his wife's parents. Panetti himself requested the court to determine his competence to be executed. Without a competency hearing, the state court held he was competent to be executed based on a Dr. George Parker's report. He was a psychologist. After hearing this, he then petitioned the federal court. Since the state did not actually hold a competency hearing, the federal court ruled that this was against Ford versus Wainwright, and they held a competency ruling which allowed him to bring evidence to the hearing. Panetti presented evidence. He was evaluated, and although he believed he was acting on his religious beliefs and had schizophrenic tendencies, which were backed by his expert witnesses, he was still able to understand that the murders he committed were punishable by execution, and he was aware he would be executed. Therefore, the federal court held that he was competent to be executed. Another example is Dennis versus Budge. Terry Dennis was a defendant who pled guilty to first-degree murder and received a sentencing that resulted in the death penalty. Dennis originally appealed to Nevada Supreme Court with his attorney Carla Butko. He then quickly withdrew his appeal and wrote a letter to the district attorney saying he'd rather die than live his life as an old man in prison. Now, his attorney was disgusted at the fact that he withdrew his appeal and was going to waive his rights, so he or she withdrew from the case and recused herself, although she does come back into the story eventually. His motion to withdraw his appeal and continue to waive his appeal rights was granted. He was ruled competent even with his psychological evaluation. It stated, Mr. Dennis had sufficient present ability to consult with his attorney with a reasonable degree of rational understanding. Mr. Dennis had a rational and factual understanding of the proceedings, including the death penalty, and that for his bipolar disorder, Mr. Dennis was taking appropriate medications that did not impair his capacity to make decisions. So although in the report he does admit and diagnose Mr. Dennis with bipolar disorder, that doesn't mean he's not capable of understanding all of the proceedings and why. So it was after his competency hearing when he was ruled competent, his lawyer tried to make a motion as a next friend to rule him incompetent and put a hold on his execution. Although he was diagnosed with bipolar disorder, he was competent to be executed. His previous attorney, tried to make next friend motions to declare him incompetent. This failed because she used this motion after his competency hearing was already ruled on, as well as she couldn't prove herself to actually fit the next friend category. A conclusion to this presentation: competency standards and rulings are left up to the state, then appealed to the federal courts. A defendant must be able to understand what the death penalty is, what waiving appeal rights means for him or her, and why they are receiving a sentence that results in execution. And when I say why they are receiving a sentence that results in execution, they need to understand why we as people, the jury, judge, our justice system believes what he or she did was wrong, not why he or she thinks what they did is wrong. A mental health disorder can affect an individual's competence to waive rights and competence to be executed. A person with a mental disorder can also be deemed competent, as seen with Dennis. Most states that have capital punishment will automatically review the sentence without the defendant needing to appeal it. And these are my references. And I don't know if I can move my face, but all of my in-text and per slide references are right in the right-hand corner. Thank you.